Hopefully we're all set to go. We're going to get started this morning. Everybody's here bright and early at 8:15. I'm Kim Havakati. I'm the Executive Director at the Foster Care Review Office. I am an attorney by trade. I kind of have this strange, unique background. I was in private practice. I won't say for how many years, because you guys will add them all up and figure out how old I am. For many years in Douglas County, and then I also ran the juvenile division in the county attorney's office there for about 10 years. I've been the administrator of the Office of Juvenile Services and ran the YRTCs in Kearney. Got involved in the whole privatization issue. That was quite an adventure in life, too. A lot of PTSD. And then now I'm the executive director of the Foster Care Review Office, and have been there for about 3 years. We thought today between Gary Burke and myself, we were going to cover some topics that we feel are very relevant for guardian ad litem, or really anybody within juvenile court. We're going to talk I'll talk a little bit about the Foster Care Review Office and what some of our data is showing. I also have a presentation on some of the recent case law that's come out in the last year, so we can get familiar with that. I'm going to talk some about the central registry. There were some major changes in the central registry this past legislative session that all of us need to be aware of because it affects all of our clients. And Gary is also going to talk about some of the major legislative changes that happened this last session. I would like to keep it fairly informal, so if you have questions or I don't get something right, please make sure and ask questions, because to me, the more interactive we are, the better. I know we have people also watching the PowerPoint via the web, and then questions can come in from them, so we'll try to keep it moving as much as possible. And as all attorneys, I promise we will take breaks. That's very important message. Foster Care Review Office. Have any of you ever been to a local board meeting in the Foster Care Review Office? Foster Care Review Office, we're a statutorily created independent agency. Our mission is really to ensure that the best interests of children and their well-being are being met. As an independent agency, what that basically means is we don't work for the governor. We have an independent board that runs our agency, but we are under the executive branch. Purpose under statute of the Foster Care Review Office is really 4 things. We're to provide direct reporting to the courts, to the legislature, to HHS, to all the other relevant stakeholders. And we do that by doing quarterly and annual reports of data. So we're to provide oversight of the foster care system. We do that through individual case file reviews. We do about 4,500 individual case file reviews statewide every year. And those are the ones that go before our local board, and we are now getting into some new realms with probation and also some other things. We are to make recommendations to the legislature with regards to what policy needs to be done for child welfare and juvenile justice. And lastly, because the state does get federal 4E review funds and money, under federal law, there has to be 6-month reviews on these children for the federal money to keep flowing. Our review process ensures that we keep that money flowing into the state. So our authorities and duties. We have a registry of foster care placements. Every child for the past 30 years that has ever been placed out of home, I have in the database. So we keep a registry. Every day we are change, adding, deleting that database as to who's in home and who's out of home across the state. We're to guide the activities of the local boards. Currently, we have 53 local boards across the state, all served by volunteers. We have a little bit over right now 325 volunteers across the state, because each board has about 5 to 7. So we have a lot of volunteers that donate a lot of hours every month looking at these cases. We are to review the cases. We also have authority to walk into any foster care facility or any foster care home. So if you ever have any concerns about a facility or concerned about a foster home and the safety of that foster home, we do have a legal authority to show up unannounced and to go in and see what it's like and what's going on. And we have exercised in the past. We also can request or participate at review hearings. We're one of the few foster care agent review offices across the nation that actually have this authority, so I can take standing in any legal case and become just like any other legal party, file motions. And I have done that now in a couple of cases. I did get a letter from our Attorney General giving me, being I am still a licensed attorney here in Nebraska, the authority to represent our agency and to go into court. And I have done that on a couple of cases that we were not happy, and my board was not happy as to how the case was going and felt there needed to be some motions. And the ironic thing is, guys, I know a lot of people think the Foster Care Review Office gets involved in termination cases and you're really looking at permanency. But 2 out of those 3 cases were cases we felt the kids should be going home, and they had not been going home. And there was just some legal maneuverings going on in the court system. So that's our authorities and duties. Definition of foster care placement. This really changed the past session as to what is a foster care placement. If you notice, it's all types of placements, all types, no matter what type. It's not just foster care. It's any type of congregate care. It's group home care. You name it, we have authority of abused, neglected, dependent, or delinquent children. So probation youth that are placed out of home, we now have authority to review probation youth. It also includes all types of placements of children who have been voluntarily relinquished to HHS or any child placing agency licensed by HHS. So technically, and we have never really pushed that part of the law, if a mother is going to give birth to a child today and she goes to Nebraska Children's Home or any private agency to relinquish rights, we technically are to get notice of that. I can tell you we do not, and we've never really pushed that issue, because in my opinion, that's a private matter, not a part of the juvenile court system. But the other change that came about this legislative session really deals with what's called trial home visits. Under federal law, when a child has been out of home and then returns home, for that first 6 months that they're returned home, that is legally considered a trial home visit. So what the Nebraska legislature did this past session is say, okay, we are concerned as a state that right now the reentry rate for kids that were out of home and then go home is running at about 30%. About 30% of them are back out of home again. The senators are very concerned as to why that's happening and what some information to see as a system what we are doing well and what we aren't doing well. So they gave us legal authority to now review cases after children go home for that first 6 months. We have not started that process yet. We're working on it. We hope to start it after the first of the year, starting to look at children that return home and trial home visits. There was also another key change that was done this past legislative session dealing with the admissibility of our findings and recommendations report. How many of you have actually seen our findings and recommendations report? Thank you. As you notice, we've kind of changed the format in the last 6 to 9 months. We've tried to make it more readable from an attorney standpoint so that you're getting the relevant information you need in a short, succinct way. But state law now says that with regards to our reports, those findings and recommendations shall, no more can, shall be admissible in court, period. There's only one caveat, and that's as long as we make that report available to all legal parties of record. So there's no more, it doesn't have to be offered, doesn't not have to be, all those type things. Basically, under the statutory change, they're to come into court. And then what the legislators decided is it's really up to a judge then how much weight to give. A judge, as you know, can give something a lot of weight, no weight. It's really up to the judge at that point. But they wanted that information coming to the court from an independent third party. So that law went into effect August 30th of this year. Current statistics. I know for most of us attorneys, we look at stats and we like to roll our eyes and go, oh my gosh, now I got to look at numbers. I always tell people that's why I went to law school, not med school. If I was smarter, I would have gone to med school. But as of August 1st, 2015, we have a little bit over 3,100 wards in out-of-home care statewide. A little bit over 1,800 families. That's a decrease of over 750 children since May of 2013. What do you think the decrease is due to? Where did all those youth go? Probation. Right now, probation's out of home rate because they also do report to us it's running around 760 youth in out of home care by probation, not including detention. So those 750 children have not disappeared. They've disappeared from HHS standpoint. They have not disappeared from the system. It's a different part of the system that they're now in out of home care. But there's no question that the major impact was on that 13 to 18 that formerly all of us would have known they were in OJS. When you look at the ages, we always like to look at the ages of youth in out-of-home care. And if you look, it's pretty much even. About 38% are 0 to 5, 32% are 6 to 12, and 30% are 13 to 18. So it's about a third, a third, a third. Not really much difference in ages. I think as the years go on and the whole probation system takes over, we anticipated an increase in that 0 to 12. There's been some talk. I was just at a meeting on Tuesday of the Nebraska Children's Commission, and one of the senators was there and is thinking about proposing a bill this coming session that says that would require that no youth under the age of 12 or under can have a delinquency petition filed against them. She thinks there should be a minimum age for delinquency petitions, because I can tell you statewide we've seen delinquency petitions against 8 and 9-year-olds. And she is not happy about that, so she was talking about maybe doing that type of requirement. Okay, my service area. So let's look in all parts of the state, and I know for many of you guys it's central and western. This is comparing August of 2014 to August 2015. I mean, we all know Douglas County and the Eastern Service Area. Douglas-Sarpy County is the largest one. They account for about, I just saw a stat yesterday, the Eastern Service Area accounts for 41% of all state wards. They also account for 47% of all the money spent in the state for child welfare. So there were some huge discussions on why that disparity and why is that extra. The 6% doesn't sound like a lot, but when you're talking millions of dollars, that's a substantial amount of money, which, what you hear then from northern, central, and western impacts the amount of money that you guys get here for services. So I don't think I'm preaching to the choir that is an issue. But when you look at the central service area, there was an increase, a slight increase in the past year, and also a slight increase in western. When we look over the last 3 to 4 years, it's been pretty much this steady amount in central and western with regards to kids. So one of the other things that we always like to do is we like to compare the percent of children in the state for the United States Census compared to how many kids are in out-of-home care. So when you look, for instance, in the Eastern Service Area, they have 7% more kids in out-of-home care than they have in the general population. But when you look at Central and Western, it's pretty much mirroring what your general population of kids under the age of 19 are in this part of the state. Race is always a big issue. We know as a state we have disproportionate minority issues within juvenile court and within the probation area. So the red line is really the percent of children in the state per the U.S. Census. So in this state we have 2% Native American, 2% Asian, 6% Black, and 86% white. But when you look at the percent in out-of-home care, what do you see? You really see a difference, don't you? So when it comes to Native American, it's more than twice the number of children in out-of-home care compared to the census. When you look at Black, it's 3 times. And when you look at white, it's substantially less. So we know as a state we have a disproportionate minority. Now some groups that I sit on have had a lot of discussion about, is this a race issue or is this a poverty issue? Which is it? And I don't think we can really come to any conclusion. To me, that's almost a chicken and egg type argument. I don't know which goes first or which goes second. We just know as a state we have to do that. And I also think it has impacted and will continue to impact this area of Nebraska, because even I was in Lexington last night for one of our board meetings, and there's no question that a lot of the cities around here have changed, and the populations have changed. And we are noticing that in our data, that the data is starting to change across the state. Placement types. People always like to know, well, where are kids placed? So when you look at state wards, now this is not probation youth. When you look at probation youth, about 98% of all probation youth are in congregate care. They only have about 50 kids in foster home. The rest are in a group home or some other type of facility. So this is strictly state wards, HHS. This has been a huge change. Relative kinship care is now about 48% of all kids in out-of-home care. And you guys have probably seen that here. We as an agency, how do I want to say this, question some of that. And you guys probably see that too. On the one hand, I think you have the argument, it's always better for children if they have to leave their home that they're with somebody they know. But then the key to me becomes is that somebody they know an appropriate placement for that child. And we've seen some cases recently that I am really questioning. You know, this foster father, yes, might be Uncle Harry, but he had a methamphetamine charge 2 years ago, and now we're putting an infant with Uncle Harry. But he's an uncle, so he's put in a relative placement. So we've seen relative kinship placements about 3 to 5 years ago were running about 24%. So they've almost doubled in the past couple of years. And have you guys seen that out here too, the push to place with relatives? And again, I'm not saying it's a bad thing. I don't want you guys to think that. I just think as a system we have to be very sensitive to the fact, is there a home study done on that relative and are they an appropriate placement? Just because they're grandma doesn't mean that they're appropriate. I suppose all of us have some strange relatives in our history, in our background. I wouldn't want my kids with either.
Haven't we lost foster homes though?
Have we lost foster homes? That's a good question, and we're looking at that. I'm going to tell you guys, December 1st, which is in a week and a half, our annual report is due out. One of the things we do in our annual report, and it will be on our website, is take a look at how many licensed foster homes there are in the state. And we're comparing it from prior years to see if there is a decrease. There is a slight decrease in licensed foster homes, but what we're seeing more is what do I say? It's in specific areas of the state. I think this area of the state got hit very hard and lost licensed foster care, especially through privatization. When you get east of Grand Island, that's not the issue. The issue east of Grand Island is, do you have foster homes that will take the right children? Everybody wants the children under the age of 3. Nobody wants the 16-year-old. I mean, that's kind of, but the issue out here, yes, I do believe you have lost licensed foster home beds here, very much. And I don't think there's as much active recruiting that goes on out here, which does then force the department to really look closer at relatives and trying to find some relative or kinship. So good question. Group facility, about 7% of state wards were in group facilities. Juvenile detention or your OJS wards, there still are about 50 to 60 state wards that are OJS wards. Most of those are parolees that went to one of the YRTCs. Now they're on parole. Those did not get transferred over to probation. So we still do have some of those. Independent living, about 1%. And then we have our runaway shelters. Really, shelters, I don't know about out here. I haven't recently looked at your data. But really, state wards are not using shelter care much. Probation is using shelter care a lot as an alternative to detention, but really, from a state board standpoint, there's not much use. And help me out here, guys. Where are your shelters?
Yeah, the Grand Island list.
They're,
Scottsbluff.
so Grand Island and Scottsbluff.
Those are also basically limited to different organizations. You just didn't fund. You just didn't fund us anymore. We had a great one for
You used to have a local one.
So really, we've really lost in the shelter area.
Our local one shut down.
Do you guys anticipate, this is just a question, so sorry, while I'm out here, I like to learn things too. Do you anticipate with probation that some of those shelters will come back in as probation is looking for alternatives to detention, or do you not anticipate that happening? And I'm seeing head nods no for you people on the web in this room that they're saying no, they don't anticipate that happening.
No, I know here we're talking about like a 24-hour safety hold for assessment purpose that we might be able to develop, but our shelter won't be.
Okay. So yes, there has been a huge decrease in shelters. Then we always like to look too as an agency is how long have kids been in out-of-home care? I mean, there's a big difference if a child is in out-of-home care for 30 days, 60 days, a year and a half, 3 years, 5 years, how long? So this is a chart that really looked at continuous time in out-of-home care. So not those children that are out of home for 60 days, go home for 30 days, go back out of home. These are kids that have been continuously out of home during these time periods. 52% of the kids at a point in time, which is August 4th of 2015, had been out of home under a year. 26% between 1 and 2 years, 12% between 2 and 3 years. The concerning thing to us as a state is that 10% of these kids have been out of home 3 years or longer. Which 10% for most of us would go, that's not too bad, but when you look at the number, that's 316 kids that have been out of home for 3 years or longer. And I'd like to say that this has changed through the years, but we really haven't seen much change in this.
Does that mean they're still part of the US system?
Yeah.
No guardianship or no permanency?
No guardianship, no permanency, still an active state ward.
Now, some of those, though, I think, like I know the ones we have here who've been out of here that long are due to funding issues. We have kids with significant disabilities that if they were to be placed in guardianships or adopted, they would not get the funding or through disability to be able to provide the care that the foster families are giving them. So what do you do with those children?
I think one of the things we have to talk about is the system, and I think, and I'll repeat the question for people on, is for those kids that are out of home 3 years or longer, a lot of them have significant mental health or developmental disability issues, that even if you have a potential placement, reality is under our current system that if I adopt that child or take a guardianship, I am getting less money to care for this child than if I continue as a foster parent. That to me seems like an oxymoron. That is not something I would think we would want as a system for permanency for these children. Now, on the other hand, I tell myself, well, at least for that youth standpoint, they don't know that from a standpoint to them. They're staying in a home where they've always been in. They're going to stay there until they turn 19, so that's a positive thing. But as a system, I think that is something we need to talk about and figure out that why have we created that type of situation that doesn't benefit? We also, I think, as a system have to talk about, and in fact, one of the cases we looked at last night in Lexington dealt with a DD case where the girl is going to age out in about 6 months and nobody's really applied for DD and there's no question she needs DD. Our developmental disability system, and again, this is the opinion according to Kim, and as a good friend of mine, Gail Steen from Lincoln, says if you quote me, you die. So I'm just giving you my opinion. But we know in the child welfare system, we have a lot of youth that really should be in the developmental disability system. And we know once they age out at 19, they're going to need that continued support. We can't just say goodbye at 19, be well and prosper. They need that DD. But our DD system is so underfunded, these youth are on that wait list for years and years if they even are lucky enough to ever qualify. So to me, at the state level, we have to look at where is our appropriate funding and what is the best silo of HHS that should be handling some of them. Because this 18-and-a-half-year-old we looked at last night, there's no question she probably should have been in the DD system 3-4 years ago.
But when you apply for DD first time,
You get denied.
and so it's very frustrating to have a child who cannot go and traditional independent living. You apply for DD so you get into DD housing when you turn, 18 or 19, and you get flat out rejected. That you're right. We really need to, because I agree with the lady said. The ones that I have that are 3 years and older are all either DD or significant mental health issues. And we'd love to put something, but there's no way available. Because people are worried if they take it as a guardianship, those children may lose the resources, the few resources that they need.
One of the issue that we're just talking about here has to do with the application for the DD process. Being were guardian ad litem here, again, this is Kim's opinion, so quote me and die. But DD came out, the developmental disabilities, or HHS came out with an agreement between child welfare and developmental disabilities that child welfare staff can apply for disability services. What we're seeing, I'm putting this on this table too, is that some of the service areas, those case managers, are requiring foster parents to apply for DD, and I think that's garbage. I'm putting that out there. HHS is the one that knows what's going on with that youth that can get it. To me, that is not a foster parent responsibility.
But they tell the foster parents that they are required to do it if they want to.
Right, but I don't think it's, to me it's HHS, so how can we as a system, and those are probably ones you should be contacting us and say, Kim, can you get in there and do some fighting on that? Because we should be in there, we, the Foster Care Review Office, should be in there fighting with HHS saying this is your responsibility, but do it. That's what this agency was created for. But the other thing this thing did that I want to put on the table for guardian ad litem, this memo, it says that, you know what, case manager, if you're denied, and we all know for us sitting in the room, 99% of these kids who apply for DD, they're going to get denied. And the ones that don't, you know, you're amazed. You go have a party. But you're going to get denied. That case manager cannot appeal that decision because they're appealing themselves. Okay, so it's one arm of HHS appealing the other arm of HHS, but a guardian ad litem can appeal. What HHS says is, you know what, it's the parent's responsibility. The parents can go in. Well, the issue is, for me, the reason we're in juvenile court is because we don't have functioning parents on some of these children. How do you expect them to go through a DD appeal process? But a guardian ad litem, at least I know in a couple of counties now, guardian ad litems have started to do that. They filed motions. The court has given them authority, and they now are doing that DD appeal. So I put that on the table that might be a viable alternative or something to consider. I know that it's, for a lot of us, I don't know the DD system, and I've been in child welfare and been in the courts for more than 25, 30 years, but I don't know DD. I'd have to learn it. But I think we're going to have to start pushing some of those issues towards the DD system to do it. One of the projects that we did, so some of this data, what it deals with is, about a year and a half ago, we set up a collaborative, and it was made up of Health and Human Services, the Inspector General, Nebraska's Family Collaborative, the private agency left in the Eastern Service Area, Foster Care Review Office, and Court Improvement Project. We wanted to know about those 10% of the youth that were out of home continuously 3 years or longer. What was their barriers to permanency? Because if we want to affect the system, let's figure out what those barriers were. So we went across the state and pulled all the cases for any youth that was out of home 3 years or longer. And you'll notice the Eastern Service Area was 304, Southeast was 82, and then when you look at the Northern, Central, and Western, with you guys, as you could tell, in Western it was 17 youth. So it is a smaller amount, but there's smaller youth out of home. So what we did with these youth then is we did an individual case file review as a group together for each and every one of these 400 and some odd youth. We then met with every case manager and supervisor on this case to figure out what was going on. So what did we come up with? All children in out-of-home care. Now, we did this study back in July of 2014, so I want to point that out. It was about a year ago. So we looked at all children in out-of-home care regardless of how long, what service area were they from. So then we looked at, okay, for kids that have been out of home 3 years or longer, what service area were they from? What stands out here? Eastern? No, I mean, that's where we have our separate juvenile courts. You look at Western, really, you guys are doing great on that. You look at Northern, you look at Central, you're getting to permanency. So the areas of the state, I mean, a 20% difference in Douglas County, which to me says something. So then we looked at ages. I got to be honest with you, this was one of the most shocking data things for me was with regards to age. I anticipated that most of these youth, 3 years or longer, were going to be in the 13 to 18-year-old range, just the type of youth you were talking about, you know, and I anticipated that it would be in that 80 to 90% were going to be age 13 to 18 because those are the ones you can't find permanency for. But look at this data, 9% of them were 3 to 5 years of age. That means that they have been out of home their entire life and didn't have permanency. That to me is sad, that for an infant we don't have anything. But then the other concerning thing to me is that age 6 to 12, that was 34%. Again, this is not the teenage population. Yes, the teenage population was 57%, but you still have 43% that are under the age of 12 that have been out of home 3 years. So when you think about it in a percentage of life situation, which is how we look at a lot of things, That's a larger percentage of life they've been out of home. So then we looked at demographics, and we looked at race. Race became even a bigger issue once you started looking at kids that have been out of home 3 years or longer. So again, we looked at first percentage of all Nebraska children regarding the census, what was their race, and that compares to the other chart. Then we looked at, okay, how many by race were out of home as of a set point in time. And then we looked at the population of those 400 and some odd youth that have been out of home 3 years or longer. What are you seeing? Look at the black population. Look at that increase. It's a 20% increase. There are 19% of the children in out-of-home care, almost 40% of all the kids 3 years or longer in life. What's going on? We don't know. I have no answers. But to me, this is some relevant data that we as a system now need to look at, hone in on, and see what the story is. So what we did is we honed in a little bit more. We looked specifically about black children from Douglas County because we knew that was the biggest area. Look at Douglas County. Douglas County, 13% of all children in Douglas County are black. 21% of all kids in out-of-home care in Douglas County are black. Look at how many 3 years or longer. Almost 50%. 1 out of every 2. Seriously? What are we doing? What's going on? I don't know if their court improvement project in Douglas County is looking at this or not, but to me this is extremely relevant.
Just a question in terms of if you have children that are going to be in this type of setting, are they trying to exclusively place them with black families, or will they place them with Caucasian families? That's more of a curiosity question there.
They claim it should not matter.
Okay, so
It shouldn't matter the placement, the race of the placement, as to whether or not they get placed. So some other interesting data facts that I just wanted to point out, as we looked at this population 3 years or longer, 90% of the parents were single. I don't think that surprises any of us, does it? 10% were married. This is the thing that upset me, though, is a third of them had intact parental rights, even though these kids have been out of home 3 years or longer. 48% of the children had a mental health diagnosis. Did that surprise any of us? No. I always, when I do this talk, to me one of the things we need to question as a system is how much of that mental diagnosis was caused by us, the system, after 3 to 4 years, compared to what they came in with. And I personally believe we, the state of Nebraska, try to do a wonderful job, but we're not great parents. We're just not. So we have to think about that. When you asked about the developmental disabilities, when we looked at that figure, 13% of the youth, so about 40 to 50 of them, had developmental disabilities that we felt as a group should have been in the DD system. 82, this is also very upsetting to us, 82% of the children had 4 or more placements, which after 3 years, does that surprise any of you? I mean, you deal with it every day. But 42% had more than 10. I can tell you we had about 10% of the kids that had 35 or more placements in 3 years. That's unacceptable. And so when we talk about children having mental health diagnoses or issues, and you've had 35 placements in 3 to 4 years, I mean, we're all smart. We know trauma. Every time you move, it's a trauma. So what have we done as a system? Especially when you knew that 42% of them had 10 or more placements.
Kim, what about the percentage of parents who have
There were a lot. I didn't include that in my chart, but I can gladly. That study that we did is on our website, and I can get a link to Sarah so she can send it out to each of you. There were quite a few. The main, for those that still had parental rights intact, 2 big issues: drug use, mental health. Those were the 2. And to me, sometimes when you talk about drug issues or mental health, I always wonder again, are we talking a chicken and an egg? I mean, do the parents have mental health issues, and that means they're using drugs, or do they have drugs and now they have mental health? I mean, I don't know. If you guys could answer that question for me, I would love it too. I think a lot of times There's a lot of self-medicating going on. But there was a high percentage of the rights that were impact the parents had substance abuse issues or mental health issues. Top permanency barriers. So then we sat down as a group and said, okay, what are the main barriers for these 400 and some children? Because if we don't look at what the barriers are, how are we helping the system? Okay, anybody surprised by number one? Past case management, supervision issues and practices, 30% of the cases. You have worker turnover, how does it affect guys? Let's talk about it. If you have 3 case managers in a year, it's going to impact that family and their ability to get permanency or services or anything else. And we know, I have to put this on the table too, that, you know, you got to remember when we looked at these cases, and when you go back 3 years, that's in the whole throes and mess of privatization statewide. So there was a lot of case manager turnover during that time, just from the standpoint of went from the state to private entities to back to the state, and then, you know, each of them had 2 or 3 case managers. It was not unusual in some of these cases where we would see that they had 12, 15, 18 cases. Next one. Sorry guys, I will take the hits on this one. County attorneys, guardian ad litems that would not or could not file TPR. We found certain areas of the state, county attorneys just do not file TPRs. They don't. Sometimes, and we worded it specifically as would not or could not, because we didn't feel we were qualified to say, well, they wouldn't do it. If you have 12 to 18 case managers, and I think back to my county attorney days, for 10 years, that's all I did was TPR trials. If I had 12 to 15 case managers on a case and I went to do a termination, good luck. Good luck finding those 12 to 18 case managers. Good luck proving all the services and when they were offered. You try to use supervisors. It becomes a nightmare. And you guys are awesome defense attorneys out there. It's hard. So we really felt it was important. Sometimes it was a would not, that we do have some county attorneys out there that will not file TPRs. Sorry, Gary. But we also, sometimes you can't. It is what it is. Court delays, continuances, full dockets, and related matters, that was 20%. That was mainly in your separate juvenile courts. What we found in the rural areas is really that's not an issue. You guys are getting into court, you're having hearings timely, things are going on. What you will find in Douglas County in particular, that if I filed a motion for termination of parental rights today, I'd be lucky to get it heard in 8 months, if I needed more than a day. So when you think about kids being out of home for 3 years or longer, it doesn't take long to get that. Need for a relative, search for placement at the time of removal. You got to remember we're going back in time because we just talked about relative placements and the increase that has been the past year or two. When you go back 3 to 4 years, there was really not a lot of search for relatives going on, and that has changed. Last one was the length of time to an appellate decision was 12%. I could tell you when we came out with this report, Judge Inbody saw it, called me immediately up and said, oh my gosh, what are we doing wrong? I give our Court of Appeals credit. They looked at it. They looked at the data. He looked at his processes and said, it's taken 1.5 years or more to get an appeal through. They have now changed some of their processes. Most Court of Appeal cases now get done in 9 months to a year. There was some talk also at some of the groups that I sit on. If you guys are familiar with Iowa at all, the Iowa appeal process for juvenile court is 60 days, bam, bam, you're out. I mean, it really isn't brief orientated. It isn't anything. You put it forward, the court makes a decision, you're done. Is that a better process to do because you're dealing with lives of children? Or are you then not giving that true due process rights they need to get? I mean, those were the arguments at the Supreme Court Commission for Children that's been talked about. Okay, any questions about that before I get into case law updates? Again, I'm going to quote my friend Gail Steen because this comes from her. Quote me on these cases and die. I hate to talk about cases to attorneys because you guys probably know them better than I do. So any of these cases come from you, please let me know. And please, I will gladly turn the mic over for you to talk about the case law updates. Okay, I didn't major in English or in math, but we had 15 cases from the Supreme Court in the past year. we had 4 Court of Appeals. I don't know where our Court of Appeals went this past year, but 4 cases, really, in a year? That's it? I can't figure out what the Court of Appeals was doing. But the Supreme Court, with regards to those 15 cases, there were 4 reversals, 1 dismissal, and 11 affirms. So our Supreme Court, all of a sudden, you guys probably noticed this past year, they've been very active in cases in the juvenile arena. I don't know if it's because they are now in the probation realm more or what. Like I said, where's the Court of Appeals? There really was only 1 published case that I found from October to June. So October of 14 to June of 15. And that's the Ethan M case. I don't know if you guys remember the Ethan M case. We talk about it as the 800th time. Really, I think it's the 5th time that case was on appeal out of Lancaster County. But the kid is now 13. Mom has custody. The court finally terminated jurisdiction, and the court affirmed it. So I think we're done with the Ethan M case. Yay. I'm going to talk a little bit later about the Trenton case, because that was reversed. There was none in July, and then the ones in August and September, I'm not really going to talk about, but you guys are welcome to look them up, so I included them on here. It was pretty much standard. So in re Shayla H. This case came out of Lancaster County with Judge Porter. It's an ICWA case. The issue was whether the applicability of ICWA when children were in HHA's custody, but physically placed with their parents. County attorney argued that ICWA did not apply because they were placed home with parents. So we didn't have to worry about active efforts. We didn't have to prove active efforts. We didn't have to do any of that. This has now been up on appeal twice. Well, it went to the Court of Appeals. The Supremes affirmed the Court of Appeals. What do you think our Supremes did? Our Supreme Court said, you know what, it doesn't matter if they're in home or out of home. If ICWA applies, period. Because what their argument was is that legal custody or that placement could change at any time. And so their interpretation of the Indian Child Welfare Act is that if you know it applies from day one. And I know Gary's going to talk a little bit about some of the major changes in ICWA. And I know we have a bench brief handout that we've given everybody on the changes in ICWA. But active efforts do apply. So that was the Shayla H. The Anthony K case. This one was really a strange one. If you guys really want to take a look at a unique case with different issues, I've got to pull out my notes a little bit to make sure. This case was really, it came out of Douglas County District Court. And these parents, it was 2 cases. One case against the state, it was a 1983 action, and one case against HHS for the same facts. It dealt with 3 kids were removed for being left alone, and then the parents subsequently had 4 more without being removed. So they had 3 kids removed, 4 at home. It was open for 9 years, 18 different workers. Kind of sound familiar in some respects here. And so the parents brought a 1983 action. They sued the state employees individually and also in their official capacity. What the court ended up saying, they ended up granting the motion to dismiss because of proper service and sovereign immunity. So if you're ever looking at suing the state, this is a great case to look at. What the Supremes ended up saying was that HHS had sovereign immunity, period, and they hadn't waived it, so good luck. As to HHS employees in their official capacity, if you are asking for money from the state, then it's in their official capacity and they have sovereign immunity. If you're asking for prospective relief, then sovereign immunity doesn't apply, so that you can go after it. But in this case, what they didn't show was that there was a continuing violation of the law by these case managers, so they barred it. They also said that I think it's important for each of you, and the reason I included this case is that guardian ad litems have absolute immunity. Because what they said is that as a guardian ad litem, you are an adjunct of the court. You are an arm of the court, And what they would need to show in order to be able to sue a guardian ad litem is that you acted outside of the scope of your authority. All right? So otherwise you have absolute immunity. There was also some service issues. I'm not sure this attorney really read some statutes on how to serve the state and didn't bother to serve the attorney general and some of those type things. So there's also some, if you ever have questions about service process against the state, this is also a great case to take a look at that because they do talk about that. And I do have copies of all the cases up here. So if I break or afterwards anybody wants a copy or wants to do something, just let me know. See, that's a good thing on the guardian ad litem. In re Net Hall A, this one also came out of Lancaster County. It was a law violation case, came out of Judge Thorson for criminal mischief. And this happened to be one of those kids that like to run a lot. So we'd run from group homes, all that type stuff. A disposition, and had been involved with Health and Human Services prior to probation. Okay? So at the disposition for this youth on a delinquency petition, there was evidence put on of prior HHS services, but there was no EM, no tracker, and there was a second group home willing to take this kid after he ran from the first one. The issue before the court is this last legislative session, there was a change in 43-286 that talks about before you can send a youth to the YRTC, you have to exhaust all levels of probation, supervision, and community-based services. That was a year ago that came into effect. And what the court ended up holding, and I kind of put a quote in your handout here, because I found this case kind of ironic here, guys. I don't, maybe it's just me, but this is the court telling themselves, you didn't do your job. Because probation officers work for the court, and this case is very clear that probation officers work for the court. So they were basically telling themselves, you didn't do your job, you do your job. But they reviewed it all, and basically they found that I'm not going to read that to you guys too. So what the final decision was that when it comes to these type situations, the exhaustion of services, you can consider prior HHS services, but it isn't a checklist. What exhaust really means is that more than an opinion, but it must be documented, it must be analytical. And here in this case, they said sending a 3A to Geneva without more was too extreme. Really never was in probation because when this youth was in HHS, it was a 3A case. And they were trying to argue that those 3A services should count towards probation so they could send them to Geneva. And Judge Thorson bought it, but really they said, you got to go back down to juvenile court and you need to put on evidence that you've tried to exhaust all others. Some of the debate that we've had over that case is really doesn't boil down to there was a second group home willing to take this youth, and really the judge just decided, I don't want this kid in a group home, I want him at the YRTC. And if that really wasn't the issue going on, if there wasn't a second group home willing to take this youth, would it have been okay to send them to the YRTC? Because maybe then you would have exhausted, but being there was another service out there, you hadn't exhausted. Does that make sense? In Ray Trenton, this is the one from the Court of Appeals. Are you guys familiar with this one at all? It's out of Boone County. It is a really strange case. 3 kids in this case were found in a hotel room, with the oldest being 12 years of age. The petition, and mom and dad were not in the hotel room. They were absent. But they left the other 2 kids in care of the 12th row. Mom and dad had to get to court. Mom and dad had to walk to court, so they were walking to court. The petition that was filed by the county attorney had no specifics, no affidavits, no reason. It had just the statutory language out of 3A. Okay? The temporary custody motion that was filed did have an affidavit, but really what the court said, that's not good enough. Under due process and reasonable notice, that's not good enough. Because what they held is that, you know what, county attorney, you can't present evidence outside of your pleading, that petition. So in that petition, you better be stating your reasons as to why this falls under a 3A. And just saying the language of 3A without specific allegations is not enough. Okay? So the Court of Appeals reversed the adjudication and remanded. There was a lot of discussion in the case. The oldest child at the time of it came up on appeal was now 13. Parents basically say that they didn't mean to leave the kid alone so long, but that she was 13. And I don't know about you guys, but a lot of 12 and 13-year-olds are babysitting out there and can go through babysitting classes. So the Court of Appeals really struggled with, how is that an inappropriate caregiver? Yes, you're living in a hotel because you don't have a house to live in, but is that really an inappropriate caregiver? What they tried to state is, well, there was some meds missing, but nobody could prove there were really any meds missing because mom and dad were on meds and that the kids ever got in them. They left food for the kids in the hotel room, so they had food. You know, is it appropriate? Maybe not. Is it a reason to remove kids? Was a question from the Court of Appeals. But the Court of Appeals, again, this is a strange appeal thing, and I bring this up for here, because the Court of Appeals says there were insufficient facts to adjudicate the dad. So they agreed, you know, these facts are just not enough. But mom also appealed, but they dinged mom because mom didn't correctly appeal as a cross appellate, so the appeal was not heard. So this case is still going on in Boone County, so sad, too bad, because now they have jurisdiction now over the kid and mom because the Court of Appeals wouldn't touch that one, but they dismissed it as to dad and said there weren't enough facts. So one of the lessons to be learned in this case when you look at it is, if mom and dad are appealing, be very careful how you do and file your appeal documents. There's been some discussions. I was just at a conference a couple weeks ago, and we were talking about this case. You know, mom has an attorney, dad has an attorney. You know, you both are going to appeal now, because in this case, you almost have to be talking to each other, saying who's going to appeal first and who's going to appeal second. Because we think what really happened in this case, mom and dad appealed. Everybody knew they were going to both appeal, but dad's just got filed first, and not by a lot, by like 10 minutes. I mean, and then mom appealed, but because they both came in as appeal and not a cross appeal, they dismissed mom off.
So if dad was dismissed out, they did place the kids with dad and dismiss the rest of the kids.
They could. They could. But it ended up with a bizarre situation to me where you have the same fact situation for mom and dad. As dad, they're saying there's not enough to adjudicate because mom, you didn't appeal it right. We can't hear your appeal, so we have jurisdiction over the kid and you. Okay. I told you, that was our Court of Appeals. That was their one big case this past year. But you might really want to take a look at that one because that whole appeal process part of it, I found very interesting. You know, some of the questions we've talked about, so does dad now have to wait for the remand to get the case dismissed? Because they remanded it, you have to wait. Does mom, this is one question we've talked about too, does mom have an action for ineffective counsel? I mean, let's pretend it applies in juvenile court. It really doesn't, that we've ever seen, or I couldn't find any case law out there. But should the attorney have known better? I mean, we've all done things we could have, would have, should have known. So, again, quote me and die. Bad county attorney, you can't just say it's a 3A. You got to allege why it's a 3A. Bad mom's attorney, I guess, for not knowing the appeal process. But the other thing I found very interesting when I was reading this, there was no listing in the opinion of the attorney for the state or the guardian ad litem. So I don't know if they weren't involved in the appeal or didn't file briefs, but I didn't see anything on that piece. And their position as to what they wanted was never listed in that position, in the opinion. So I don't know where they sat. In re Zachary D. This is an infamous case out of Omaha, and I think I've been involved in this case for 10 years. This kid's been a state ward for about 9 of them. Omaha case, Judge Kelly, there were 2 kids involved in this case, Zachary and Alexander. Zachary had been adopted, so Zachary was out of it. Alexander was basically a legal orphan at age 3. I think he's 12 now. The case started in Colorado County. Where's Colorado? I don't know. Started in Colorado County and ended in Douglas County. This child was placed, he's now 12, he was placed at Envisions in Norfolk. He's a DD youth. And this becomes down a fight between who pays for what. The NFC worker, who's the private entity in the Eastern Service Area, became aware during the case that negotiations regarding whether Envisions is a licensed child care facility have come up because they're a DD facility, they're not a child care licensed facility. But the worker doesn't tell anybody that that's an issue. It's an issue for payment. So NFC goes and starts negotiating with Envisions. Basically what happened is Envisions came in and said, you know what, I want X amount of dollars per day. If you don't pay me this per day, this kid is out of here. NFC says, I'm not going to pay that amount. And so it became this negotiation of who's going to pay for what. So allegedly, there was an agreement to allow the child to stay, but then NFC didn't pay. So Envision says, fine, we will take the kid for X amount per day, but I need a check by this Friday at this time. I can't remember the exact time period, but we need a check by here. And NFC doesn't give him the check. All right? So then Envisions gets mad and says, you got your 2-day notice, I want kids out of here. We're done. So this is what the smart worker does then, again, with tongue-in-cheek. Worker goes and moves the kid without notice to anybody, claiming it's an emergency removal. And for all the legal parties in court, and then file the, 3 days later, files the emergency removal after they've already removed the kid. I don't know where the emergency is if it's payment issues. There's no safety issues there. It was a payment issue. So in this case, the guardian ad litem files a contempt action against NFC and saying, you violated a court order. There was a court order that said that this kid can't be moved from Envisions. And just because your company doesn't want to pay, that's your problem? That kid stays there unless the court orders otherwise. That was a contempt action. So what the juvenile court judge did, and this was very interesting too, we could ask some questions about this. The court found the department and NFC in contempt of court. They ordered them to pay a $5,000 fine, or they could purge the contempt by doing 2 things. Because remember, this is a civil contempt, so you got to get the keys to the jailhouse door and all that good stuff. They could do it by preparing and distributing a written policy providing that it initiate and have immediate contact with the children's guardian ad litem, county attorney, case professionals whenever a child's place is threatened for any reason. So that the judge said, I will forgive the $5,000 if you have a written policy that says you contact everybody before you do it. And that this policy prepare and distribute and prohibits the deletion or destruction of email. Because what had happened in this case, that case manager couldn't find any of the emails from the patients. They just kind of didn't. And that angered the judge. But seriously, come on, in this day and age, you can't find it down in emails. So the judge got mad. Okay? So he wanted that policy to say that while the case is open or pending and no less than 6 months following, you will keep all emails out of the case. Okay? So HHS appealed and said, look, you can't be telling us what to do by a policy. We didn't willfully do something. It's a violation of separation of powers that you, the judicial branch, is telling us, the executive branch, what we have to put in a policy. And what do you think the Supremes did? Supremes basically said, willful does not mean malicious, it means intentional. You consciously do something. So you don't have to show maliciousness for a civil contempt. The guardian ad litem argument And I don't blame, and I know this guardian ad litem in this case very well, and I've worked with him for years. His point was, it's easier to beg for forgiveness versus to ask for permission, and that's why NFC did it. They figured they could just move this kid and come into court and say, oh, via culpa, I'm so sorry, we were naughty. And could just get their hands slapped, and the judge got angry and said, I'm not slapping hands, I'm slapping big time. So the Supreme said that there was no notice of a constitutional argument regarding the separation of powers, so we're not going to hear it. But being it's a policy and not a rule or a regulation, yes, court, you can require that as part of your jurisdiction. But HHS has to do a policy. We were laughing too as we were looking at this. Deleted emails, what does that sound like right now? You want to get in the political world? It's a little bit political now about deleted emails and where they go and what magic server those deleted emails happen to be on. I personally, the dissent that Judge Stephan wrote is a very well written dissent, I feel. And there were two judges that dissented and basically said this was not willful compared to the other five that said no, this was willful. And you just have to show intentional means willful. The other two judges said no, really willful means malicious, that you are maliciously trying to do something, and the other judges denied. So I think that's an interesting case. I'm seeing more and more of contempt actions. In fact, I just was talking to an attorney out of Omaha, a defense attorney who has now filed a, help me out here guys, and I'm having a brain lapse. He's going on in juvenile court, has filed in the Supreme Court to say, give me the body back. Habeas. Has filed a writ of habeas corpus, thank you, in the Supreme Court as a defense attorney. So we'll see what happens with that one. He said it's his third one that he's trying, so he said maybe sometime he'll actually win one. Slow no. This was an interesting case, and I'm familiar with this one too. This came out of Douglas County. The girl in this case, Sloan, was in court under a 3A docket and also a law violation. At the time when it came into court, the 3A filing was against her father. So she's on probation, 3A against the father. Father hit her, chained her to the couch. County attorney files a 3A against dad. Mom comes into court and says, I want placement. Here's a birth certificate. I want placement of my kid. And also, here's a district court temporary custody order I went and got that gives me temporary custody of this kid because she's divorcing dad. Juvenile court basically said probation had placements and no as to placement. Okay. But the judge also told the mom, you know what? You need to file a motion to intervene. But just because you're the biological mother, you need to file a motion to intervene. And you didn't do that, so you don't have to. So attorney appealed, went to the Supremes, which I thought the judge was totally wrong in that. But went to the Supremes. Basically what they said is, you know what? Probation can't have custody. In other words, legal custody remains with the parent. This is one that could use is on probation. This is a case that really deals with what authority there is by probation once the youth is on probation, and parents still are legal custodians. So, you know what, county attorney, if you think mom's not appropriate or somebody doesn't, then you need to file a motion against mom. Otherwise, you know what, mom gets killed. And mom does not have to file a motion to intervene. Now, they did not, like I said, they didn't do placement, but they did say mom has standing. Mom could be in there fighting. You know, there's some language in here that I think is worth taking a look at too, because it talks about the definition of parties under 43-245-19, and the court defined parties to include the juvenile and his or her parents. They didn't make a differentiation in that case, whether it's a probation case or a 3A case. But if you have jurisdiction over the kids, you have jurisdiction over both parents. Period. Because that's one of the legal arguments out there with regards to probation cases is how much can you court order parents to do on a probation case. So this case did talk about that. They also did talk about in here, because, you know, to me, when it comes to a mother, it's pretty easy to prove that the mother is the biological mother. Here's the birth certificate. I gave birth to the child. Here it is. They're my adoption decree. Dads are another story, and they kind of touch on that there is a difference between a putative dad and a legal dad. If they are the legal dad and can prove to the court that they are the legal dad either by a birth certificate or by paternity testing or through a marriage, they also they're an automatic party to the case. If they're the putative dad, and they haven't proved that, then they have to file the motion to intervene. Because at that point, they have to file a motion and then they have to take that affirmative to prove I really am the dad. Does that make sense? Kind of, sort of. Last one. This one just came down. For those of us from Douglas County, this has to do with the whole Nico Jenkins case. This is Nico Jenkins' sister that was convicted of murder and was sentenced. But it's a very, very important case with regards to foster parents, and that's why I added it. Case has really impacted my opinion on placement questions and who has standings. Also, with regards to what if you look for relative placements later. This case overrules some previous cases, so that's why I wanted Jorius G and some of those older cases. It did overrule some of those. What happened in this case is there was a 3A filing with regards to the mother. Like I said, the mother ends up getting convicted for murder, ends up going away for pretty much the rest of her life. You had one kid originally. When she was in jail, she gave birth to another kid. Both those kids were placed with the same foster parent, non-relative foster parent. At the time of the placement with the non-relative foster parent, the case manager came in and said, Mom wants us to consider putting this child with a sister down in Las Vegas. We started an ICPC. We started a home study down there to look into placement. So everybody knew it. This is not one of those we're hiding the ball. Everybody knew it from the day the case started. As we all know, that deal in the ICPC realm, that could take months. It took about 6 to 8 months for that ICPC to be done in Las Vegas. That home ended up being approved. And so the Judge Thomas, was getting ready to move the kid down to the relative. The two kids down to the relative. Foster parents then said, oh no, we're going to file a complaint to intervene, and they wanted to file to change, fight to change the placement order. And I don't know about your courts here, but I know some of ours out in Douglas County have been pretty lenient about when foster parents file complaints and motions to intervene, they're just routinely granted. Fine, you can get it. And in some of the courts, they're pretty much treating them like any other legal party and letting them file motions and doing things like that. But really what the Supreme said in this case, foster parents lack standing to appeal an order changing placement. Outside of your scope, you have no right to appeal that. You cannot file that motion. It's not your realm. And they're not entitled to intervene as a matter of right. Period. Because in juvenile court, as we all know, that juvenile court does not have equitable powers. So they can't equitably let them intervene. So they have to look at, was it a matter of right? And the court said, no, it's not a matter of right. And if you are allowed to intervene, it is for one little specific purpose, and that's just to show your qualifications. No more than that. So it has limited, in my opinion, really a lot of the ability of foster parents within juvenile court. The main reason that the court gave as to why they changed their previous decisions is because it was a statutory change in 43-1314 that basically states foster parents are entitled to notice of any hearing But that does not mean they're a necessary party. And the law changed to state that a couple of years ago, 3 to 4 years ago, and I guess I just didn't pick up on it. So what the Supreme Court interpreted that to mean is you have no right to call and examine witnesses. You are just there for this little reason because the law was changed. You're entitled to notice, but you're not a necessary party. But you're not a necessary party, you don't have the right to do everything else that a party does.
That's kind of yanking the rug out from under some of these foster parents that want to adopt. You got a family member that's out of state and says, here I am, I'm approved.
One of the reasons, the question was for you guys in your offices, is it really does yank the rug, but then you have to think about those cases where a child has been with a non-relative foster parent for years, and then 2-3 years later, the case manager finds Uncle Harry in Florida that now wants the kid that the kid has no relationship with, and they want to ship the kid off. And a lot of times, I know at least in the courts I'm familiar with, you file motions for the foster parents to stop that from happening. I think this case is going to say, good luck. That you're going to have to be working with, and I guess the reason I brought this case up for guardian ad litem work is guardian ad litems are probably going to have to bear the brunt of doing some of this. And filing some of these motions for change of placements or a disagreement with change of placements because foster parents aren't going to be able to, or there's a real question if they're going to be able to. Or you're going to have those foster parents really work with their county attorneys, because defense attorneys probably are not going to be, if I'm a defense attorney for a parent, if I'm the parent and I'm representing the parent, and the parent wants a kid with Uncle Harry in Florida, that's what I got to represent. The county attorney and the guardian ad litem are probably going to be put into a different role on that case. Now, one of the questions I have for you guys that I would love for somebody to answer, what happens now? I can tell you I know of 3 cases currently across the state, and one of them is from this area. So you have 2 children, same parents. Older child is adopted. Parents have new baby. That new baby is now part of the state board, and is placed with different foster parents. Okay. Now, new baby is free for adoption, and now adopted sibling wants placement of that child, and are claiming, look, we're a relative. We should be treated as a relative kinship placement because we have a sibling of the child over here. Did everybody follow those facts, kind of? I know there's a case, I can't remember if it's other cases. So, if I am adoptive relative, adoptive parent of a sibling, do I have standing to file in juvenile court for placement of that baby?
That's a little different.
It's different than this case.
Right, but I think it's really what you said. I think I know which cases I think Shirley read that. And the facts are, there was an older sibling that was in juvenile court. The new baby comes along and is adopted. All along, those adopted parents said to HHS, we have multiple siblings. We're licensed foster parents. We really want you to see it. HHS basically said, no way. Maybe a little cynical, but
No,
I think that they had promised this baby to another family, and now what's happened is this family has come in to intervene and say, hey, wait a minute, aren't we a better placement because we're raising a full-blood sibling of this? And I don't know where it is, but that it's a little different because they got another child.
Right.
And they reached back to try to get
The older.
it reminds me a little bit of this, that this wasn't new news.
And does that become relevant? Right.
Early on, and before the first baby was born, they notified HHS that, hey, we're probably going to adopt this public sibling. Can we at least have place for this thing? They said, the child's been with the foster parents for, that's probably 4 or 5 months. Not having a child.
And that, it could be that could be one of them. There is a case out of Douglas County that I know has a scenario that I'm talking about where Judge Johnson did give that adoptive family on a motion to intervene, the ability to intervene in a case, and then they're filing motions for change of placements, and it's all this big mess in there. And so our question really was, is how will this case, or will it not impact those?
I mean, can you legally have standing once you're adopted, you're no longer the biological, I mean, you take on the family you're adopted through. So,
Well, see, that was our discussions too. From a legal standpoint, once you're adopted, that might be your blood sibling, but that's a blood sibling, not necessarily a legal sibling, which I hate to say that, guys, and please forgive me, but from a legal standpoint, legally, that is what happens. So how do you get standing?
I think this case says you don't have standing. I think this case totally says you no longer have standing.
I think this case says you don't have standing, but what I've seen is, or what the discussion was, can you then file for that sibling as the adopted parents? I'm not filing now as foster parent or potential foster parent. I am filing as next friend of this minor, who's a minor and they can't file anything, so I'm not filing as that. I think that case is probably the next one that's going to be coming down in the next year and a half, because it is a little bit different twist from this in re penis and eternity case. I also wonder in this case if it would have mattered to the Supremes if everybody was not aware of this relative from day one. In other words, if it was one of those cases where these children have been with the foster parent for 2, 3, 4 years, and then they go find this aunt, if that would have changed it, I don't know. But you read this case, they are very strong on the fact that they have overruled these portions of Joria C, and they've overruled a couple other cases. When we came on and said this, it is now the law's changed, this has changed, this is not the law anymore. I mean, they probably said that 3 times within that case. So I found it an interesting case. I think it's got some interesting twists. Like I said, in the courts here, how do they usually handle guardian ad litem? Foster parent and their ability to come into court. And you might have to talk loud enough so people can.
I think it used to be until that other case, they couldn't intervene except until that case came out for the purpose of change of placement. That was it. And I think that's the only way they can now, I guess, until this.
So that's my case law. Don't quote me or die stuff, okay?
The way I remember the facts of this, I think there is still a little gap where foster parents have some standing. And I think there was one case they distinguished where the foster parents had sat down with the grandmother who said, I will relinquish my rights, but to you, the foster parent.
Yeah.
And that specific scenario, the court said, yes, that gives the foster parents some kind of standing because they've already, that was the reason non-relinquished your rights. And that was something that I remember the facts correctly. I think there's one little kind of...
There's one little potential loophole in there if there's an agreement. I read it the same way. If there's an agreement between the biological parent and the prospective adoptive foster parent, then maybe you could still be able to do some of that. But
you're not foster parents, you're now prospective adoptive.
Right.
But in juvenile court, you cannot take a conditional relinquishment.
Right, that's it. But in juvenile court, you can't do a conditional relinquishment. So I'm sitting there thinking, okay, how does that? I could see where that would work outside of juvenile court. But I don't know how within juvenile court you'd go through some of that because of that conditional relinquishment and the validity of it and are there promises and all that good stuff. So I think it's interesting. Like I said, to me, the most interesting thing this past year is that all these cases but one came from the Supreme Court. So we have a Supreme Court this past year that's been very active in the juvenile arena. I don't know why. I mean, because 2 or 3 of these cases were ones the Court of Appeals decided and they took them up. 2 of them, I think, the Supremes themselves just grabbed it and said, we're gonna take this up. So I'm not sure what the story is, but it's been a very different year. So any other questions on case law?
Well, one issue that I've seen in case law, and I didn't see it much on these cases, is the forensic reference doctrine. And there was a case, I don't remember which one it was recently, but guardian ad litem testified that she didn't child's best interest. The court said you don't even get to a best interest analysis because there's a parental preference doctrine. So best interest is completely irrelevant. If there's one parent and no allegations against that parent is that child, regardless of the guardian ad litem and the best interest analysis.
And that's that Sloan O case. When you look at the Sloan O case, they talk a lot about the parental preference doctrine, and that it applies. And you have a constitutional right to your child unless you, county attorney, file some allegations that say they're inappropriate. Otherwise, your kid is your kid, and you have the right to it. Now, placement might be a different issue, but as to custody, you get custody, period. Which I think helps clarify, because how many years, I think that it's been a debate in juvenile court for as long as I've been practicing there. And that's why I said, in that case, to me, it's very important that we start talking about the difference between putative dads and legal dads. Because what a lot of the courts have a tendency to do is they're fine with doing that with mom, but when it's a dad, it's kind of like, oh, I think you need to file motions to intervene, and then we're just going to make you jump through these hoops. But if you read Sloan O, in my opinion, under that parental preference, if you can prove you're the legal dad, and the county attorney hasn't filed against you, you can walk into court and say, give me my kid. You don't have to make me go through supervised visitations and all this other stuff. My kid is my kid, and you know what, HHS and county attorney, you better have done your background and checked into both parents. Sorry, Gary, that's my read of the case, that it should change, and I think rightly so, the work of HHS and the county attorneys. When you do that filing, don't just assume. When you have a child, there is a mom and a dad. Somebody was that sperm donor out there that you need HHS to look into. Who is that, and is there a legal dad or not? And I think you're right. The parental preference, they came out in that Sloan O case very strong on that.
I think there's been another case here, though,
Yeah.
Probation wasn't involved, it was a straight up juvenile case, and no allegations whatsoever against one of the parents, and that parent intended to get custody of the child.
There was also one other case, and I didn't put it up there because it was more than a year old. And the reason I want to bring it up, and so I'm kind of doing a song and dance into after break, we're going to talk about central registry and no-fault petitions. 3A no-fault, due to no fault of the parent that, you need jurisdiction, all that type of stuff. There was a case out of Lancaster County that went to the Supreme Court now about a year and a half ago that when it comes to no faults, it's worth taking a look at. That case was a 3A no fault that came in because the child had some mental health issues and mom needed some help parenting. And what the Judge Thorson ended up doing was court ordering mom to have a psychological done, and for mom to have therapy. So mom's attorney appealed and said, this is a no fault here, and you're requiring me to do these things. This is not due to my fault. Judge Thorson disagreed. Court ordered mom to have to do it, went on appeal. Supreme Court said, no, you're right. This is a no fault. You're going to do a no fault. You're saying due to no fault of the parents. You cannot require these parents to do anything unless it directly impacts that child, such as family therapy or something like that. It has a great impact on what a court can order, with regards to these no fault petitions. When do we have break? Oh, no, you should have stopped me. See, we're attorneys. We need breaks on time. Sorry, guys. Okay, break. How's that? For people in your offices, break. How long a break do we have?
15 minutes.
15-minute break. So until about 5 till, which really means probably 10. I also know us. People in their offices, actually, it was on the case we were talking about, and they responded. So that's awesome. It was their case. The judge ruled that neither adoptive parent nor sibling has the right to intervene on that case. But the sibling has some rights as foster parent to present credentials. Also, HHS to show that it's in the welfare of the child to not be placed with the sibling. That's what currently. If you could you quick respond and just say, is this case on appeal? And we'll see if they respond. Because I had heard that there was that case was going to be appealed. So that might answer some of the questions that we talked about, which I think would be very interesting. Okay, next topic. Central registry. I just know, even when I was county attorney for all those years, I knew nothing about the central registry other than there is a central registry and you never want to be on the central registry or have your clients on the central registry. But there's been some significant changes this past legislative session with regards to the central registry. So first, what is the central registry? It's created under statute 28-718. And basically what goes on, central registry is all investigative reports of child abuse or neglect. And they're classified as either one of two things. Either they're court substantiated or agency substantiated. It's that agency substantiated that many times causes some of us to get squeamish. So when is a report court substantiated? Well, this makes logical sense for most of us. Where either the court has entered a judgment of guilty upon a criminal complaint, which relates to child abuse or neglect, or there's been a 3A adjudication in juvenile court. So once that parent is adjudicated in juvenile court or convicted in adult court for child abuse and neglect, they're automatically placed on the central registry. Next question is, what's not included then? Well, first let's talk about when is a report agency substantiated. This is where, for me, it gets a little fuzzy, because then it's based upon HHS staff that make the determination. But it's whenever the department determines by a preponderance of the evidence that a child abuse or neglect occurred. And that this evidence is gathered through both HHS and also law enforcement. So it's basically them looking at it and basically saying, yes, we think this occurred, so we're going to put the person on the registry. Yes, there are ways to fight that. You can, once somebody's on a registry, there is a whole process by which you can try to get your name off a registry. But the agency substantiated one, I know currently HHS is working on some regulations to try to shore this up, to give better guidance to all of us as to what it is you do, because otherwise, to me, it's more of a flip of a coin as to who's looking at it and what their view is today and if they think this is substantiated or not. The court substantiated ones are easy for me. It's like, okay, there's been an adjudication, there's been, some type of conviction. Why is it important? When you think about it, background checks. I know for each one of our local foster care review board members, every 3 years, I have to put them through this kind of background check. And if they're on that central registry at all, they cannot sit on that local board by statute. But also you and I know schools do, daycares, churches, volunteers, almost every group puts people through background check. All right? And if somebody's not on that background check, on that central registry and should be, then our kids are not protected. That's simple. But I'm sure all of you have represented people where being on that central registry has greatly impacted them, or could greatly impact them. So you need to know. Effective court filings. There's a new law that took effect on August 30th, 2015. What that new law states that with regards to a no-fault petition, 3A petition, whether it was filed as a 3A or redesignated and pled out as a 3A no-fault will never, ever be on the central registry. Now, if you think as a defense attorney, there are some very strategic advantages of doing that. On the other hand, if I'm talking to county attorneys, and sometimes guardian ad litems, I'm saying, you guys got to think long and hard before you take these 3A no-fault pleas. Because we've seen cases out there where they're pled in the methamphetamine use case, baby tested positive. Baby tested positive, pled to no fault. No fault methamphetamine use. Not sure how you have no fault meth use, but obviously you do. And I understand legally why sometimes that gets done. But we all have to understand as a system under this statute, that parent will never be on the central registry because it was a no-fault petition. So when that daycare calls in to check, they could now be driving our school buses and working in our daycares because they're not going to be on the central registry. All right? So we have to me, this change in the law makes it very imperative from all sides that we really examine what is the best thing to do. Whether you have a county attorney lens on, a guardian ad litem lens on, or a defense attorney wins. I understand defense attorneys. I try to plead every case to a no fault. But they changed that statute where it has to be either a criminal filing or a fault petition. Okay?
Can we go back to that last bullet point there really quick?
Yep.
So if I'm reading this correctly, is if the parents, plead to it, it's adjudicated, they go through it, everything's asked them, the case is dismissed, then they're immediately removed from, or do they have to go through the expungement process?
Okay, ask me the question again so I make sure I
So, okay, it says if the case is dismissed, is that talking?
pre-adjudication.
Oh, okay.
Dismissed pre-adjudication. Because remember now, when you talk about agency substantiated, you can have a fault case dismissed, but if HHS determines that it's agency substantiated, even though the case is dismissed as a fault, they can still be on the central registry. What they're saying here is if the case is dismissed pre-adjudication and it's a no fault, you cannot be on the central registry and they cannot agency substantiated as a no fault. Does that make sense?
Yeah.
Right. I think the biggest thing to me, too, is because what we see a lot, and we used to do this in Douglas County, too, so I'm not saying it, but you would file a 3A fault, and then you would amend by interlineation sitting in court to do that plea. And so this language, I think, was specifically designed for that situation. So when it's redesignated to include a no fault, and you're sitting in court and you do that, they're not on the registry. So if you're a defense attorney and you represent these parents, you want to make sure that they're not on that central registry. And I probably would be double checking to make sure this is a no fault. They better not be on that central registry because we know how it could impact. So what does this mean for county attorneys? Well, when Gary and I did our county attorney presentation back in October, we told them very succinctly, it directly impacts whether that individual's name is on that central registry. So you got to keep this in mind. Instead of maybe pleading to a no fault, you do an anticipation and dismissal and put the case out for 3 or 4 months, hoping the parent gets their act together. Do you look at some other methods of trying to do it, county attorneys? Additional findings not on the central registry. A couple of the things that are not on it, court pending. And that's when a criminal complaint or a juvenile petition has been filed but is still pending in court. It has not been adjudicated. On the central registry, that will come across as court pending. So you're not technically on the registry, but it's pending. Not everybody has access to those. Some of us do. Okay. Or it's unfounded. Those are reports that are not court pending and they're not agency substantiated or court substantiated. So if it's unfounded, you're not on the central registry. Because how many times don't we have, well, this family had 8 calls to the hotline and 7 out of the 8 were unfounded calls. Those unfounded calls are not on. Of note, and this comes from HHS, so I wanted to add this, once a report of abuse or neglect is determined unfounded, that decision is final, period. And that perpetrator can't later be placed on the central registry for that same report. If they do something new, they can be. But once unfounded, always unfounded, never on the registry. Make sense? Even if more information comes to light. Minors on the central registry. One of the funny things that happened about a year ago is Senator Colby Kowash started looking at the central registry and went to HHS and said, tell me how this all works. And what they found out is, oh my gosh, we have infants on central registry. We have 5-year-olds on the central registry. Why do we have minors on the central registry? What's the deal? Some maybe practices that HHS needed to improve on. So the senators decided we're going to help that along. So minors on the central registry starting August 30th of this year, no minor under the age of 11 can be placed on the central registry, period. So that 8-year-old that's charged with sexually perpetrating in juvenile court under a juvenile delinquency petition on a sibling, a 2-year-old sibling, never on the central registry. Okay. For a minor child that's 12 to 19, they can be placed on the central registry for their action, but there cannot be a finding of court pending. So in other words, they have to have actually been either adjudicated in juvenile court or convicted. The other important thing when it comes to age 12 to 19, there is a very detailed process, statutory process, that if the youth is that age, there's an automatic ability to seal that, a notice that has to be given to that minor. So in other words, you don't want to see, the concern was you would see this 14, 15-year-old that's out there and does something stupid, and now they're 25 and they go to apply for a job and they find out, oh, I'm on the central registry and I've been on since age 15. You know, just kind of like sealing a records in juvenile court. There now is a process by which you can get that minor's name removed from the central registry once they're an adult. Some of the area of the state here does have alternative response, correct? When it comes to alternative response, those are not also on the central registry. Do you guys know what I mean by alternative response? It's kind of a fancy voluntary case. It's where HHS has determined that the child is conditionally safe and probably doesn't need to be filed in court, but they need some further services. There's a pilot in 5 counties in the state where they're looking at alternative response to really go in there and give some services and to front load the system. But again, because there has not been any finding of abuse neglect, they're not on the central registry. The department maintains the central registry. They enter all the findings. They determine whether a name is placed on it or not. So you can see who they is and who has that authority. Okay, it's all the department. And that's pursuant to statute. That's the way it's set up. How long does a name remain on the central registry? I asked that question. So, what, are you on forever? Yeah. There's no time limit set by statute. There's no regulation. So once you're on, I guess. But the department can, and the key word to here is may amend, under statute expunge, or remove a record at any time upon good cause shown in notice to the person. So no matter who you represent, you can always file the appropriate documents, and I know they're available on HHS website trying to get somebody expunged off of the central registry. Do they have forms? Yes, I think on their website there's some actual forms now that they can use. The last I knew they were still working on the minor forms. I don't know if the minor forms are all done. I think they are too, and on the website I haven't double checked that. But yes, they have forms. Impact. I mean, we know professional licenses, employment. I mean, if you have a nurse or anybody in that medical profession or any mental health professional, you're on the central registry, you can't get a job. Bus drivers, school workers, anybody that works around kids, daycares, no way. Volunteering, I don't know about you guys, but I know my own church, or even Sunday school teachers and people like that do central registry checks. From a liability standpoint, so many of your nonprofits and volunteer organizations almost feel they have to. Some of the schools too, we always put this one up there, you can prevent parents from helping out at school activities. Which as a parent, I can understand because I'm not sure I would want some of these people helping out at school. But so the schools, I think, at least I've seen even with my own kids when they were younger, are getting stricter and stricter and doing some more checking into central registry. Who has access? It's confidential, as it should be. Only access to HHS tracking system. Individuals on the central registry can always request a self-check. So if you have a parent or you have a client who thinks they might be on it, they can always request and say, am I on it or not? Okay? Anybody who is on the central registry, of course, just like everything else for us legally, if they sign a release of information to any individual or organization, you can always get into it. Because how many times, or if you think about it, whether it's clients or even yourself, you go in to apply for a job, they hand you a little piece of paper that says a release of information so we can do your background check and see if you're on the central registry. It's pretty common anymore, especially if you're, I mean, any of your service providers out there, they have to do it under their contract with HHS. I have to do it by statute for all of my staff and also for all of our local board members. Has to be done, period. County attorneys, of course, can be provided with nearly information as long, see this is a key too, as long as it's used to prosecute child abuse or file a TPR. So a county attorney doesn't have automatic access to everything, but if they make a request, then they have access to it. Any unauthorized release is a class 5 misdemeanor. Again, my agency, even as an independent agency, I do not have access to the central registry. I have to file with HHS a request, and then they give me the information back. I gave you some people up here who you can contact with questions in the future. So I talked with Neely Boyer, one of the HHS legal, because I thought maybe it would be important for you guys that if you look at the central registry question, I don't understand, I don't know what it is I need to do. You guys probably know Dorothy or Lori. I mean, they're HHS legal that are out here that can get you geared to the right people. And then I also gave you the attorneys' names for Eastern Lancaster and Rural Southeast, just in case you ever had any questions or needed to contact. I don't know how Lori covers all of Western Service Area. I don't know how Dorothy covers all the Central Service Area. So, any questions about the Central Registry? Nope. Well, then I am going to turn it over. You guys have heard me enough. Before I turn it over to Gary, though, I do have one thing to bring up that I did not get included in the packet. In the back, and for those of you in your offices, we'll make sure and send them out electronically. There was a major change in federal law within the past year, the Strengthening Families Act, that dealt with a lot of things, but one of the things it requires, and I have 2 handouts for you in the back, both come from Appleseed, so these do not come from us, they come from Appleseed. But part of the Strengthening Families Act in Nebraska is requiring each state to pass regulations regarding the rights and duties of foster parents and what they can do. And the whole goal of it is foster kids should have normalcy in their life. And normalcy is the goal. And the standard you need to look at is what is the ordinary, reasonable, prudent foster parent. Does it kind of sound like law school? Now we have a foster parent. But the ordinary, reasonable, prudent foster parent. And what does that look like? They're working on some regulations to help guide us, but it's really to help foster children be able to have a more normal life. And if you think about it, you guys all know it. If foster parent Mary wants to stay overnight at foster parents at friend Sue's house, how big a hassle is that? Everybody in Sue's house has to go through a background check before they get to have that overnight. Seriously? I mean, there are some protections. Or if foster kid Mary wants to play volleyball or play the cello, or get an ear pierced. Oh my gosh! Everything has to go through the case manager, correct? The whole object of this is to set up some regulations where they can have normalcy and do a lot of the normal things that kids can, and that foster parents have the authority to do that. So there's 2 things in the back for you. One is just a front back that they are using as just kind of what the law guidelines are. But the second one I thought might be of interest to you too that Appleseed just came out with, and it's a guide for board stakeholders with regards to the normalcy findings under the Strengthening Family Act. And it has some key questions that they're recommending are considered by all of us, and also questions that the bench should ask. A couple of things that this law also did that I think are very important that you have to keep in mind. Now, starting, it used to be once a kid turns 16, you're supposed to see independent living plans. And I heavy emphasize supposed, okay? Supposed to see independent living plans. That now is lowered to 14. Starting at 14, you're supposed to start seeing independent living plans. The feds also said, you know what, states, we are tired of seeing what they call APLA, but it's another planned permanency living arrangement for young kids. In other words, self-sufficiency, independent living, and they're 8 years old. Because a lot of states do that because it impacts some financial things. And the feds basically said, you can't do another planned APLA, another planned living arrangement unless they're 16 years or older. So don't be looking at independent living for that 12, 13, 14. So there are, and those are all detailed on this handout. I wasn't going to spend a whole lot of time on it, But I think from a guardian ad litem standpoint as to what foster parents can and cannot do, you probably really do want to pay attention to those regulations as they go forward in the next 60, 90 days, because it will help give guidance as to those foster parents and what we expect. So, thank you. Now I am going to turn it over to Gary.
What we said, all right. All right, you have handouts. There's so much material that I've got covered here that I didn't want to do a PowerPoint presentation. But you have handouts on all the legislative material. Now, I will tell you that I am basically here for self reason. First off, I'm glad to be able to do some CLE out here in Western Nebraska. We don't have to go to Lincoln Hall to get our credits. That's step number one. Step two, I will not claim expertise in the area of juvenile law at all, period. I've only been practicing law in Nebraska for full time for 5 years. The deputy county attorney for 3 years, and the deputy Perkins County attorney for less than a year. So I'm on a learning curve, and that's why I am part and parcel of the Nebraska Children's Commission. I'm part of the Legal Parties Task Force that Kim has control over, and basically, you've probably all done it before. Kim was looking for somebody from a county attorney's standpoint in Western Nebraska to join the Children's Commission. You've all done it before. You slide your cursor up, you go to hit the delete button, and you accidentally hit reply. So I volunteer. So let's look at what we've got here for just some brief legislative changes here. All right, you've got the LD 15 bill, the guardian ad litem changes. Those were effective July 1 of 2015. I think what's important there, and all of you as guardian ad litem, you're probably all familiar with the new paperwork requirements that you have, everything that you need to do to meet the Supreme Court's requirements, and obviously for new purposes here, a copy of any report or recommendation of the court or a copy of the court checklist must be submitted to the foster care review office. Please ensure that we do that going forward. And obviously, we're all up to speed with the itemized billing statements that are required, and I'm certain we're all doing those on a timely basis at this point. Juvenile justice sections 2 and 3, we're looking at the status offense youth page there. Status offense youth shall not be placed in a juvenile detention facility or in a staff secure facility without the staff secure facility being restricted solely through that supervision. And they shall not be placed out of the home. All right, those two requirements have to be met. Fingerprints of status youth offenders shall not be taken. You've got to remind your sheriff's offices of that. I know I've been doing where I'm at in terms of the issues with the counties I'm at. Sub-E is the one that's really very important. Prior to filing of a petition for status offense, the county attorney shall make reasonable efforts to refer the juvenile and family to community-based resources. Failure to do these efforts in the petition is a defense to the adjudication. All county attorneys are fully aware of that now. We covered it very extensively at the October County Attorneys Conference, but I haven't seen it yet, but I'm certain it will be exercised. And we've got to get kids out of these community-based resources. If not, I'm certain we'll see that defense and adjudication. Restraints. You have new restraint requirements. Restraints shall not be used during a juvenile court proceeding, and they will be removed prior to the hearing unless the court makes a written finding of probable cause after providing an opportunity to the juvenile's counsel to be heard on the use of the restraints. Interesting that I had one problem with Perkins County already. We had a young man who was going to Scott's Club. He lost it. Flat out lost it. We had to restrain him at that point. The judge made a specific ruling at that time due to the nature of how he reacted in court, and even his counsel agreed, yeah, we will have to restrain him at this point. So, once again, it seems that when you're making law back in Lincoln, it kind of hits Western Nebraska first sometimes, and we don't even know when it happens. We've got the Youth Independence, Bridge to Independence Act. You'll note the requirement there that the last court hearing before jurisdiction is terminated for a child who's 16 years of age or older is only called the independence hearing. Now, this is still, as Kim, I understand, this is still a volunteer program for the Youth Independence Act.
Correct.
Correct. So it's still a volunteer program, but if you put your child into that program, then you will have them terminated out in what they then call the independence hearing, and that will be the way you terminate jurisdiction. Finally, I want to cover a point here. Kim was able to secure some information directly from the Native American tribes. And the Appleseed organization vetted the entire two-page report here on these changes to the Indian Child Welfare Act, or as I prefer, the Native American Child Welfare Act. This outline was vetted by the Native American tribes. And so it's a judicial bench guide. I'm not going to go through the entire legislative packet. As a side note, I will tell you I hate it. You have to see like some other talks about LB or whatever, and they don't give you the actual citation or give you a copy of the statute itself. I gave you a copy of the statute. I hate getting references to LB so-and-so or whatever the number would be. It's important to note, the Indian Child Welfare Act jurisdiction now is with the Indian courts. And the district courts have concurrent jurisdiction if the child is not on the reservation. So nothing has basically changed from that standpoint other than you're going to be looking at requirements now that for a Native American child, their preference is going to be placed in. And I remember this years ago in Colorado, they were kind of ahead of the curve there. If you had a child who was, let's say, an Arapaho or another southwestern tribe, and you had a child that was born and was a different tribe, Sioux or whatever, that's the preference. You don't want to get outside of it. You don't have to be tribal. You can now place a child in the Native American setting with a different tribe. That preference is going to be even over and above a family who wants to take a child on and will promise to raise a child with those Indian background. So that's one of the major changes I think they've recognized that Indian jurisdiction will now be, or Native American jurisdiction will now be Native American jurisdiction at this point. So use the two-part judicial checklist. Please disseminate this to as many people as you can. It has been vetted by the Native American tribes in Nebraska. Now, for purposes of kind of looking at other, other concerns or the like, county attorneys, you guys get the question all the time, but we sometimes get it first. What's going to happen with juvenile if they come in and they have some kind of determination, whether it's juvenile need, whatever problem status they are defined to carry at that point. You guys tell your clients this, but we get the question first. No adjudication by juvenile court on the status of the juvenile shall be deemed a conviction, or shall the adjudication operate to impose any civil disabilities ordinarily resulting from that conviction. Adjudication of the evidence given in the court shall not operate to disqualify the juvenile in any future civil or military service application or claim. We have a lot of kids that are out there that have that question that comes. 43-280, that's the adjudication section. And that's very, very important. Say you guys are GALs, you get the question all the time. We obviously get it first. What's going to happen? I was going to go to the Navy. I was going to enlist in the Marines. What's this going to do to me now if I'm taking a juvenile court and there's some kind of adjudication? So remind your juveniles that part of the issue here is the adjudication will not have that civil disability or criminal disability to it, and that's under Nebraska state statute. It's a reminder to you, 43-2. Part of the problem of being a county attorney setting, I think when we're looking at what we have to do as county attorneys for petitions, the county attorney or city attorney making a determination whether to file a criminal charge, juvenile court petition, offer pretrial diversion or mediation, transfer the case from juvenile court to a county court or district court. There are criteria to determine how you should consider that. There's over 15 particular criteria that county attorneys are supposed to really look at to determine where you're going to place this case. And they're very lengthy in terms of 43-276-1. They deal with everything from what your gang member to what your outstanding needs are in terms of jeopardizing your health, safety, and welfare, or how your parents or non-parents are involved. 15 criteria. So to a certain extent, there is some frustration level at the county attorney, some city attorney levels that we've got a lot of criteria to establish. So when we're trying to figure out if it's a fault or no fault petition, it's basically saying it's not with the snap of our fingers that we can come up with this stuff. In particular, when you're getting county pressure from a lot of people that are telling you that little boy did the following, and that's a felony, why aren't you moving that child into a felony status at that point? And you got to explain it to him. I'm sorry, he's 15, he's 16, or she's 17, or 18. Why did you do what you did? Why did you transfer the case to juvenile court when we had him on a felony? In particular, the sheriff's office is going to give you a lot of briefings on that. So as a GAL, we want to help support some of those changes that have to be made simply because you're representing the children. You're the guardian ad litem at that point, and you have the provisional issue to be able to assist in terms of any prosecution at that point as to why was filed the way we filed at that point. So this worked out well. As I said, I claim no expertise in this field. You've heard from the expert. Kim's been doing this a long, long time. I'm relatively new to it. So I'm telling you that I'm here because I want to continue to learn the juvenile process, and it's a continuing, ongoing, changing process. Some people consider it to be like nailing jello to the wall. That may be the best way to describe it sometimes. So we finish up. But to say I gave legislative materials to you, please read that to your convenience because we're now wrapping up. You've got your 3 hours. All right.
Okay, a couple of things being we have a forum, thanks Gary, that I thought maybe I would paint a little picture on what's coming up on the horizon for this potential next legislative session. One thing Gary mentioned that I'm always open to any volunteers out there. The Nebraska Children's Commission has created a legal parties task force. I do chair that task force. It is made up of judges from across the state and defense attorneys, guardian ad litem, and county attorneys. We're really trying to, our first goal was to work on the guardian ad litem statutes and make recommendations to the legislature on that. Our second goal this year, we have been working on what we call professionalizing the juvenile court workforce and doing some trainings, and whether it's with guardian ad litems and county attorneys and things like that. What we see in a lot of areas of the state, especially in the county attorney realm, is most of the attorneys that practice in juvenile court are right out of law school, don't have a lot of background, don't have a lot of experience. One of the discussions we're doing within that work group is why is there mandatory CLE requirements for GALs, which I think is a good thing, don't get me wrong, but why don't we also require it for county attorneys or for defense attorneys? I mean, if we want to professionalize the workforce in juvenile court, why wouldn't you be looking at, for all of us that practice in juvenile court, we should have to have some type of dedicated CLE hours. So this group is working on that. And there is a Supreme Court Commission for Children coming up in the next couple of weeks, which I hope to be brave and try to bring that up and not be shot by some of the people there, because I do think it's important. I mean, I think it's very important that guardian ad litem too, don't get me wrong. But what would be wrong with requiring our county attorney, they have to have CLEs, but if you're going to be in juvenile court, 3 out of your 15 hours have to be within juvenile court area or something, so that you do. Or, defense attorneys or anybody else if we really want to do that piece of it. But the other thing that group is looking at and going to be working on over the next year that I'd like to, when we have a little bit extra time, talk to you guys about, and that's a rewrite of 43-247. I'm going to tell you some of the struggles, and I would love to hear some of your views as to 43-247. So we have A. Due to the fault of the parents, this happened, or due to no fault of the fault of the parents. Okay, I can kind of understand that. But then we have B, status offenders. What are status offenders? Other than something a county attorney doesn't know what else to file, so we file a status offender. Let's be realistic. I mean, I in all my career, I have never tried a status offense case. Have you guys ever tried one? They always flip. I mean, always. Every parent walks in and says, yeah, my kid's ungovernable, I'll plead them. All right, thank you. It was an easy case as a county attorney. I didn't have to do anything. A lot of states do not have status offenses in juvenile court. Truancy is not handled within juvenile court. The philosophy of some of those states is, what is a court going to do? Court order you to go to school? And you don't know? Is that really getting to the problem of the issue? And, one of the discussions I guess I'd like to put out there is with regards to these 3Bs, is probation the right entity to be handling a 3B? Are we trying to hold kids accountable on a 3B? Or is it really more of an HHS type? There's usually, with most 3Bs I've ever dealt with, there's issues within that family. I mean, there's some dysfunctional issues. The that whole family needs some help. It's not just that kid. So what is the right way to handle 3Bs? Or do you look at changing 43-247? And then the last part of 43-247 that I struggle with a lot are 3Cs, your mental health commitments. Do you guys use mental health commitments, 3Cs out here much? Lincoln Tech. Some counties love to use them. And when you look at 3C, I think 3C was written as it's like an adult mental health commitment, except in the juvenile court arena. The kid's so dangerous right now today, we need to do something, or they're a danger to themselves or others, which is fine. But what we see statewide, what we see in some of our reviews is we see 3C filings where kids stay at home. And I'm struggling with that because it's like, well, if they're so mentally ill and dangerous today, and you file a 3C, how can they stay at home? And then how does that 3C stay home for 3, 4, 5 years like some of them we've seen? And that becomes the case with review hearings. I mean, should that 3C have to be more, if it's a true mental health commitment, then it's for that 60, 90 days. And then at the end of that time period, you got to be filing one or the other, 43-247 for jurisdiction. I'm just throwing some things out there that we see some real differences.
Do you see a lot of confusion in expertise as far as push between HHS and probation? As far as who's doing what? I don't know about anybody else, but I get a lot of that here on cases that were maybe filed as a 3B, switched to a C, and nothing is happening because there's
Or
confusion.
if you switch from a 3B to a 3C, you just switch payment sources.
Yeah.
So really what those decisions are fiscal decisions and not what's really best for the kid. It's a question of who's going to get paid.
It's a hot potato.
It's a hot potato and you don't know what to do. Because I think in fairness to probation, most probation officers, who I have the utmost respect for, they weren't trained in the status offense social work world. They were trained in probation officer accountability and responsibility and all those abilities, not in the social work world. And really, a lot of your 3Bs are more the social work world. But yes, we do see a lot of that. We see affidavits from probation officers on probation cases for 3A no faults. There's been an increase statewide of filings of 3A no faults, almost double compared to the prior years, because it will be the affidavit I've seen is kid has completed no probation and still needs therapy. File a 3A no faults. And it do. Kid needs therapy, 3A no faults. Parent comes in, parent leaves. Yeah, I'll believe. Yeah, my kid still needs therapy. And now HHS has to pay. Which to me, again, we're chasing the money instead of chasing what's best for the kid. Because from a systemic view, for me, what I struggle with is finding you have probation, a probation officer who's been working. Now you have HHS and a case manager, and if I'm a family or a kid, now that's 2 or 3 different people I'm dealing with in different systems, and they all work differently. Are we really helping, or are we just trying to chase where the money is? So I guess I would put on the table or really welcome you guys to join our group. As we look at 43-247, are there some better ways that we can set that? One of the things also under 43-247 that I talked about on one of the cases is some courts have taken the position that when it's a probation case, they have no authority over the parent, and they can't order the parent to do anything. We have other courts that have taken the position, you know what? At that case we talked about, they are now a legal party. I can order that parent to do something. Can we? Can we not? If we're going to keep it in probation, do we need to clarify that language so that all the courts are doing something different? But also, if I'm a parent, I'm sitting here thinking, this is my flip side. As all of us good attorneys do, we look at both sides. My flip side is, look, if my kid was out there and my kid shoplifted, and now I'm going to get involved in juvenile court and you're going to make me go to therapy, don't you think there's some allegation against you that something's wrong with me? You know, how far can you intrude on those parents' life without requiring due process? You're going to require me to do something. Don't I have some due process rights? Is it just because my kid did something, I now can be court ordered to do something? Does that make sense? I mean, that's what I think about in my brain. It's like, I don't know. So what are the judges out here doing with regards to probation? parents aren't a party. I mean, and I think that's how some of them are. I mean, you know, most of the rural judges, I'll tell you that I've seen, that's how most of the rural judges are. Except for juvenile court judges, which are a different animal and beast to begin with. I see all of them really say, no, we have rodeo in the whole thing.
I've seen someone in the parent state, so that's where that 3/8 thing next goes.
Right.
You see that in the system. I've got a truancy case right now. Won't go to school. Absolutely been in court, probation violations numerous times, and probation says, this kid is compliant, you know, they're in shelter, but what do you do? Look at his parents. So, his parents got charged on that.
Well, that's it. But do we, I mean, what is the best way from a legal standpoint? Do we want, I think that's a great example dealing with truancy. Kid's not going to school. Well, yes, that's a truancy issue, but we all know the kid's not going to school because mom or dad has a kid staying home to babysit, or mom and dad aren't bothering to get the kid out to go to school and really don't care if the kid's at school or not. That's as much a parental issue, if not more, than a kid issue. So where should the filing be at, or against, or who?
I think it depends. I mean, you do have parents who are doing everything they can to get that kid to school, and you just have in some circumstances, a behavioral issue or a disrupted child, or the kid who they're dropping them off, and the kid's taken off after they go in and sneaking out the back door. And should those parents have criminal charges against them? No.
Right. So I mean, do you guys agree or disagree about looking at the language of 43-247?
I think there can be changes.
I think the BC is custody, all custody. Who's got custody? We have situations in Lexington where we have a teenager and their kids got, their parents have gone back to Guatemala or whatever. Satisfy a probation, okay, what are we doing now? Who's got custody? There are no parents. Just turn loose out in the street. Probation has no ability to place them anywhere. I mean, that's a fiasco, absolute fiasco.
Yeah.
Well, I'm sure all of you have read the. Right. I'm sure all of you have read the paper. You know, the whole discussion is about probation. What I tell people, because we were charged under statute to start doing review of probation youth. We have piloted that in some areas of the state. We haven't been out here yet. We are seeing some issues, and I'm not saying it's directed at probation, but more legal issues that come up. I'll give you a case that we were looking at. 3B, status offense. Mom happened to, at one point, work for the county attorney. And these are 3 kids that got adopted from Guatemala, have lived with this family for about 4 or 5 years. She convinces the county attorney to file a status offense against all 3 kids. Okay, fine, they do. She then kicks the kids out of her house and puts them in, and so the county attorney puts them in shelter. So fine, the judge orders from the bench, rightfully so, that, you know what, probation, go start looking for a foster home for these kids. They don't be in shelter. So probation finds a foster home, which is good. Mom refuses to sign paperwork to get the kids out of shelter. She's like, they got to sit in shelter, they need to learn that lesson. And I am the legal custodian under statute. And until I sign that paper, those kids are in shelter. Which is true. They are the legal custodian. The parent is.
So the guardian ad litem, they take over parental responsibility for saying.
So the defense attorney went in and filed a motion for a GAO, and the judge said no. Don't need it. Mom did finally sign the paperwork. The kids are now in foster care, but now the mom calls the foster home every day saying, I'm legal custodian, and the kids have to do ABC. And the kid has a doctor appointment here, and you need to get the doctor's appointment here. Because I am the legal parent. And they still have educational rights. And you know what? I don't want that kid going to that school. And I don't want that kid playing football. Because that kid needs to learn that lesson. So again, and that probably is an extreme case, but to me it really brought to my mind the whole piece about legal custody issue with probation. I can tell you, I have heard and talked with Ron Johns, who runs the Scottsbluff Detention Facility. He has struggles with some of this legal custody issue because a kid goes into detention. Judge says they can get out on some alternative, or they can go home. The kid doesn't even have a pair of pants, or the kid needs glasses, or the kid needs some medication. Parents are still legal custodian, and so it's probation says go get it from the parents. Parents you can't find, parents don't have the money, parents are long gone. Whose responsibility is it to make sure that at least some of the basic needs of these kids are being met? I mean, so I agree with you that legal custodian portion is a huge rub. And when you talk with the courts, which I don't disagree with the judicial branch either, when they say, you can't be in custody of us, I mean, in custody of who? That, separation of powers, we are the courts, we are not set up to raise children or to be custodian of children, so you can't make them custody of the courts. If you're going to keep probation within the judicial system, then legal custody has to be with the parent. So I think a lot of the rub that, at least, in Lincoln that I hear every day, is not about probation or the job they're doing, as much as some of those legal rubs that just commonly are happening. The other question I was going to ask you about probation, because I've heard some of this statewide too. There is a case, one of the recent cases we just talked about, there's a line in there, the one case out of Lancaster County, the probation officers work for the judge. Correct? Yes, they work for the judge. And there's a line in that case that says they work for the judge. So what we see in some counties is that probation officer just walks right in and talks to that judge on probation kids whenever they want to without defense attorneys there or knowledge of it. And if you're thinking about it logically, it makes sense to me because it's like, well, I work for the judge. If the judge called me and that's who I'm employed by, I'm going to go in and talk to the judge. But shouldn't a defense attorney be involved? Or the guardian ad litem, if you're going to be talking about what you're doing with my kid that I'm legally here to advocate for? Does that happen here? I mean, I can tell you it happens in other counties. I don't know here because I've never practiced in your courts here.
I think it depends if you're still on the case. If the kid's placed on probation and you're released at that point, then technically we don't represent them, and it's just like any other probation case as you would see an adult, and they have open communication because that's what the probation laws give them. But if the court chooses to retain us on that case because they perceive that there may be issues and they want that child to be able to have the representation and answer questions, or there's other stuff going on, then I think technically we still represent them, and under ethical laws and the rest of it, you can't have ex parte communication about changes in placement and other stuff about my client without me being present.
But then think about this. We just looked at some data with probation cases, and I don't think you guys are surprised about that. They were looking at how many of probation cases had legal counsel, and it's about 2/3 statewide. About 65% of kids in juvenile court have defense attorneys. That means 1/3 of them don't. So if you're one of those that don't have an attorney and that probation officer walks in and is moving your placement and changing, how do you ever find out? I mean, who's going to advocate for you? There was a senator, one of the senators at a meeting on Tuesday was saying she's looking at proposing legislation that every delinquent youth has to be appointed an attorney. If they can afford one, fine. Which kid can afford an attorney? Let's face it. Maybe they need to look at if the parents can afford it. Maybe the parents should have to be hiring an attorney. But I know with most of the courts I've ever been in, they go off the kid list of the parents. When I was county attorney, Willie Lisa's kid was in juvenile court, and then he had a court-appointed attorney. So I think the owner of Godfathers probably could afford an attorney. But I mean, how would that change things if you required that every juvenile delinquent has an attorney? I mean, I think the counties are going to go nuts. Looking at Gary, I mean, it's going to raise county expenses. You know. Or an attorney, one of the discussions we had is, oh, sure, only an attorney had to be appointed if there's discussions that youth is going to be placed on the home. Because a lot of probation cases, they just, kids stay home, they move along, they do their, 3 months, case closes, really no attorney needed, but once a motion to revoke probation is filed, then should they have to have an attorney to look at the motion to revoke?
And if you want to get technical, if you look at the Supreme Court cases that have come down over the last 4 to 5 years that says that a child cannot be held to a reasonable standard, they don't know, they cannot waive Miranda, so if they can't do that, then how can they make a determination in court without a legal representation that they can make, the determination they should admit. If they can't waive Miranda and they are not a reasonable person under the standards by the Supreme Court in the United States, then how can they legally waive that?
You tell me. I've seen 2 cases in this past year. Neither of them were from this area, so I'm not saying this area. One was an 8-year-old, one was a 9-year-old, both delinquency charges, and kid fled. No attorney. I'm just like, how can, I wanted to call up that judge, to be honest, and say, what, how does an 8 or 9-year-old plead to a delinquency case with no counsel? Why wouldn't you be covering yourself and having, if you were a judge, and have at least legal counsel? And then if there was legal counsel, the question is, to a delinquency. And yes, these were some horrific cases, don't get me wrong, they were, but I'm still not sure that 8 or 9-year-old has the mental capability to do that. So those are some of the cases why they were talking about maybe having a statute, no kid 12 or under being filed against it in juvenile court. But then also with regards to requiring attorneys and in juvenile court, and really the discussion really was around once that legal motion to revoke is filed, the legal counsel has to be appointed at that point. Maybe not before that, but from that point on, you have to have legal counsel. That was one of the suggestions, so I just thought I'd throw that out to you guys and see. Any other issues you're seeing with probation out here? And that came across wrong. I'm not saying probation per se, because it's not probation. To me, it's the legal situation that the statutes have created. I still feel like we're caught, part of the argument that, and I was involved in it, why we wanted to get rid of OJS was to get rid of this, between probation and OJS, and the finger pointing against each other. I don't feel this change has stopped that. It's just different people pointing different.
He's so nervous.
So I don't see a change.
Drew, what time is it?
Oh, B2I changes, bridge to independence. Part of, Gary talked a little bit.
It's nice you didn't have to go to Lincoln, though.
Under the statute, the foster care review office, we do reviews on all bridge to independence cases after they've been in the program for 6 months. Every 6 months we do a review because these are 40. We're trying to get as many 40 young adults as we can. There was a committee created about 9 months ago to look at expanding bridge to independence to delinquent and status youth. There is a talk that there might be a bill at this session to expand bridge to independence to delinquent and status youth. I can tell you guys there's been some pushback. And the pushback from some senators has been, why should a kid be able and eligible for a program because of the acts he or she committed? All right? I know. And so I think there's going to be, my bet is you might see some legislation this session on it. I think they will probably be looking, and I would love to hear you guys' input on how you word that, because I think you have to be a little bit more particular about what that language looks at. I can tell you for every youth in the young adults in the Bridge to Independence program, they get what, $750, $60 a month for the program. So for those youth that are taking advantage of it, it can be a huge benefit.
It's a civil conviction, and they've done their time, and this is a reformatory court, not a criminal court, then what's the difference? If we're supposed to be reforming these children and giving them the opportunity to be successful in life and make them what, others have said, appropriate citizens, excuse my language, but then what's the difference between that and someone and the others? Just because it's a 3B or a 3A, what's the difference?
That's the other side of the argument. I mean, there are both sides. So I think you will see some legislation that would probably be worth taking a look at to see how they end up structuring some of that. I think Senator Bowles is the one that did a lot of the original Bridge to Independence legislation 2 years ago, and I think she's looking at, is there some way we can? Because you all know there's status offenders you guys represent or delinquents that really have no home to go to. There's some that, yes, you'd have homes to go to, and you're angry at the parents because apparently the parents just don't let the kid back home. Those are probably not the ones in my mind that should be qualified for the Bridge to Independence. But we also know we have kids out there that they have nobody to go home to. I mean, they looked like a 3A case. So do we require the system to have to file a 3A to access a program? I mean, I don't. Those are just some of the discussions, just throwing a couple of things out there. Last thing I just wanted to, two quick things. Gary was right. There was a change in statute, guys, for all guardian ad litem's report. You are to be sending our office a copy. You may fax them to our office, and we will make sure that they get them, but you are to be sending them. The thing that we are trying to work out, and I hope to be able to get to attorneys in the next probably 3 months, is there's a lot of cases you guys have that we're not in the process of reviewing, and so do we have you send all those reports or not? Or is it once you get notification that we are, because you guys get notification, correct, that says foster care review office will be looking at, the Smith case on X day at X time. You get those notifications.
Yeah, inviting us to the thing.
So once you get those notifications, does that then trigger that you're just send to us your most recent guardian ad litem report? So you don't have to do it for everything, just once you get the notification? I don't know. I'm trying to, if any attorneys are willing to help with me work through that process, I would be very interested in that, because it's very important to me that my staff get the guardian ad litem reports, because I think sometimes unfairly we ding guardian ad litems for not doing their job when really they are. We just can't tell from the documentation because we don't have the reports. So how do we bridge that gap where we make sure, as a foster care review office, we get the reports so that we make sure we're getting the best information and giving credit to all you great guardian ad litems that are doing your jobs. Because, in our in-focus documentation we don't usually find anything about guardian ad litems, unless you showed up at a family team meeting or something like that. But otherwise, we really don't get that information. So I would be very interested in us working together to come up with what's the best process.
And do you want those facts, or can you also do by email?
Either or. Doesn't matter to me. It can be email or fax. Part of the problem with email that we run into is if you're not on nebraska.gov, how secure is that email, and I'm sending it in a secure fashion or not, because there's so much HIPAA. I call it the HIPAA laws. I mean, bibbidi boppy boo. I mean, we do run into something about it. So how can we set that up? We've looked at, as an agency, can I set up a Dropbox, a secure Dropbox where you guys could just drop them in and then we can go in electronically and pull them out? That's why I haven't pushed this issue yet, because I'm trying to come up with some easier electronic method that attorneys can use.
If we need to file those guardian ad litem reports, or those
No, but we are on justice. But we are on justice, and all my staff have access to justice. So if you're e-file, then I can have staff get them off of justice and through the e-file.
But can we, I don't think we can get on it, can we?
Well, did the recording actually show up the content of the report?
Content of the report does not show up. No. If you don't,
It just showed up as part of my report.
But it just shows up.
Email it to the person, like yesterday I got one e-filed to me, like the guardian ad litem e-filed it, so the notice that came to me, I didn't print the report out.
If you're on the email, you notice by email.
But if you're just looking up justice, you're not going to be.
Right.
Great idea. So let me, let me go back to the Chief Justice and to the justice people, because if they can do that and include us automatically on the email notifications, that would make everybody's life easier, because that way we're not exchanging all these things, and I don't have office staff going, well, we got 50 GAL reports today from across the state, who gets what, and then I almost need a full-time staff person figuring out, well, this one goes to Larry, and this one goes to Curly, and this one goes to Mo.
Well, and then it's there.
But it's there.
The certificate of service that's electronically generated shows it to
Great idea, thank you.
And then you guys can access the full report,
Right.
I could.
Right, great idea. Oh, thank you. All right, that excites me. Because I think it would be easier for everybody, and that way you guys don't have to worry about it.
Because we feel that one of the questions aren't exactly.
Oh, the questionnaire?
Yeah, they're so hard. I know I typically just send, or I sent you a letter that says, well, really, here's what the cases we have.
Right, and that's, we have questionnaires because some federal guidelines, we need to use some of that. But to me, what I'm most interested in is either send an email to my staff or send your last report, whatever's the quickest and easiest. You don't have to complete the questionnaires. We just want your updated information of what your concerns are. I mean, I don't care what format it's in. I don't care if it's on the questionnaire. We use the questionnaires just so that we can document that we've at least made an attempt to try to get people to respond to us.
The other concern I hear from my fellow guardian ad litem is, we don't know what you've used that for or who got that information.
That information stays with us. It is not shown to the parents. I'm going to put a big but on it, okay? Because if it goes into our findings and recommendations report, those are filed with the court, which then it's kind of up to that attorney for the parent if they're going to show them a copy of our report. I cannot control that piece. We do not share any information we get. I can tell you right now, I have a huge complaint filed against us, and what it boils down to is we, looking through some documentation on a case, found some concerns with regards to a foster parent. We put that and felt it was relevant to put it in our findings and recommendations report so everybody knew, look, in some of the narratives there were some concerns that this was going on. Okay, fine, it got filed with the court. Excuse me, I'm losing my voice. But then Dad's attorney gave Dad a copy. Okay, fine, that's, But then Dad turns around to give it to foster parent. So foster parent has now filed complaints that we are disparaging his integrity and it's all a lie and, he's going to sue all of us in the state because we're impugning his, moral turpitude or whatever. My point is, you should have never had your hands on that to begin with. And really, it was between Dad and his attorney. They gave it to you. We did not share that information. So I know it's a long answer for you. We did not share any information with anybody other than legal parties. But again, because you guys, I know some of you do defense work too. Sometimes you do give it to your clients, and that's fine. That's your call. That's what you represent. So I'm not going to make promises that parents will not see it. They will see our final report. They will not see your email. They will not see any of the documentation that anybody sends us. They will just see the final report. You as a legal party can look at the other stuff. Does that make sense? Last thing I just want to conclude with is, we were even talking about that case in Grand Island during break. Don't be afraid to use the foster care review office to your advantage or to gather information. If you have concern of a case with your guardian ad litem or parents, all you have to do is shoot me an email and ask a special request, and we'll set it up and we'll do a review of it. Or if you have the situation where, you don't know, should this child remain with this foster parent, or now you have a relative, or you're not sure what's going on with all of that, to me, that's part of the job and role of the foster care review office is to provide oversight. And I think this agency has not done a good job in the past of reaching out to the legal community, so that's why I appreciate the Bar Association letting us come and talk to you guys to say, we're here as much for attorneys or for anybody else as, I mean, our overarching mission, like I said at the very beginning, is the best interest of the children. But we are all here for the best interest of the children. So if we can work together on some of this, please just contact me and we'll do a case file review on any of the cases. Now, I'm not saying you might always like what we have to say, but at least we're something that you can be used. Do we have any questions from online? Any questions from you guys? Otherwise, I know how attorneys hate to get done early. They just cry. Any questions? Otherwise, thank you guys so much for this morning. It's been fun. And for interacting with me. I love to interact. And thanks to Gary for his time.